Many of the American beliefs that we've held for over 200 years were derived from fears of the tyrannical British. Colonists had no free speech or freedom of assembly. They were subject to punishment and unfair treatment for minuscule crimes, and they could be stopped and searched for any reason at any time. Situations like these prompted James Madison to construct the Bill of Rights, which created fundamental American rights that the government could not impede. One of these rights, which is listed in the Fourth Amendment, states that no one shall be subject to unreasonable search and seizure without probable cause. The amendment was vaguely written for the purpose of allowing new interpretation as to what is deemed unreasonable search and seizure. New interpretation seems inevitable due to the recent emergence of the digital age, which has brought us new technologies such as high-capacity smartphones and remote-controlled drones featuring film-grade cameras. This rapid advancement has made this technology become so widespread that now almost everyone has a smartphone. The Supreme Court has dealt with the situation of determining unreasonable search and seizure in the digital age on many occasions.
As citizens of America, we expect that the personal liberties guaranteed to us by our Constitution shall not be ignored. It seems obvious that using a GPS tracker to record a vehicle's location should be very circumstantial. However, this wasn't always the case.
We used to be able to slap a tracker on a car anytime, so we slapped a tracker on their car and we're able to follow them for using the life of the battery, or then we could swap it out whenever they're in. But then the courts ruled that's an intrusion on your privacy.
The case that Sheriff Balaam was referring to was U.S. v. Jones, and it was a crucial win for the privacy of the people. Making sure that law enforcement obtains the legal documents before they can track your car is a large step in laying out Fourth Amendment protections in this modern era. But what about my phone? In 2014, Riley v. California made the judgment that a warrant was required in order to search the phone of someone who's in custody. The courts are recognizing the significance of cell phones and the personal information they can contain, and they're treating phones like other personal property.
We treat phones and devices as containers. So it's just like a safe or a house or a garage. We can seize it and then apply for a warrant. Just because we seize it, we can't look at it. I mean, we have to leave it as is, and we have certain technology and things that we do to keep it off the network, make sure that no changes are made to the device, essentially so that as we seize it, it can't be changed and manipulated.
We have seen amazing progress towards incorporating the Fourth Amendment into the digital age. Law enforcement doesn't have the ability to track us or seize our phones without sound reasoning. Our protections from unreasonable search and seizure have undoubtedly grown with these cases, but we still should be concerned about the Supreme Court not addressing how drones apply to the Fourth Amendment. Florida v. Riley determined that a warrant is not required to observe a person's property from public airspace. So what is stopping the government from using drones to look into my windows?
After all, Florida v. Riley took place 30 years ago in 1989, which is far before modern drones like this little guy were even created. The lack of legislation could be easily exploited by both the government and the people, which is a circumstance that needs to be avoided.
It's much tougher to hover a helicopter and look through somebody's windows, right, to be at that level than it is to fly a drone down at that level and look through. So that could be an added restriction for a drone, just because of those possibilities.
The digital age is just a precursor for greater technologies to come, and it's necessary that the government is able to keep pace with the evolution of technology. Gray areas in legislation, such as that with drones, allow problems to arise and rights to be violated. Protection from unreasonable search and seizure has come in the digital age, with phones and GPS tracking, but we are still unsure of how drones will be treated in the Supreme Court. As more and more technology is introduced, interpretation of the Fourth Amendment will continuously need to adapt so the freedoms we hold dear can be with Americans for generations to come.